Well, good afternoon to you all, and thanks for joining us today from the lesser lockdown state of Victoria, and welcome to our launch of the Council's report on sentencing for image-based sexual offending in Victoria. I'm Arie Freiberg and I'm Chair of the Sentencing Advisory Council, and I'm joined today in giving this presentation by the project team who prepared this report, Anna Charlton, the Legal Policy Officer, and Paul Shollam, Manager Statistical Analysis and the data analyst on this project. Before we start, I'd like to acknowledge the traditional owners of the land on which the Council's office is located, the Wurundjeri people of the Kulin Nation, and I pay my respect to their elders, past, present, and emerging. We intend to keep this presentation relatively short, less than 30 minutes, and in the interest of time, we'll not be holding a Q&A session at the end. However, if you do have any questions, you can contact Anna directly, and her contact details will be provided at the end of the session. We'll be recording and uploading this presentation on YouTube for you to enjoy later. So what are we talking about when we're talking about image-based sexual abuse? Well, what we are referring to is those activities that include creating, distributing, or threatening to distribute nude or sexual images of a person without consent. This includes behaviour that you might sometimes see referred to as upskirting or revenge porn. But even though it's a bit of a mouthful, image-based sexual abuse is a more accurate term, and that's how this form of abuse will be described in today's presentation and in the report. Image-based sexual abuse is illegal in Victoria under the Summary Offences Act, and the various behaviours are all addressed in detail in the report. So what kind of crime are we talking about? Well, Victoria first passed laws criminalising some forms of image-based sexual abuse in 2007. At that time, the main problem was perceived to be upskirting, that is, taking and sharing images of a person's genital region without their consent, whether or not they were wearing clothes over it. That's a sexual offence which often seemed to be committed against strangers. Then in 2014, more legislation was passed creating two offences. These were targeted mainly at sexting rather than upskirting. That is, preventing people from sharing or threatening to share sex without permission, but also making sure that young people who did share sex with an otherwise consensual relationship weren't charged with child pornography offences, as had occurred on many occasions. More recently, research has suggested that image-based sexual abuse, and particularly threats, can be used to coerce people to stay in a relationship, engage in sexual behaviour, or do other things they don't want to do. That is, there's a growing appreciation that image-based sexual abuse is strongly linked to family violence and sexual offences, something the project team will touch on during today's presentation. So how many Australians have experienced image-based sexual abuse? And the short answer is a lot. In 2019, a group of researchers surveyed thousands of Australians aged between 16 and 49. And nearly a quarter of the people they surveyed had experienced some form of image-based sexual abuse, as you can see here. Even though that's already a high proportion, it may still underestimate how common this is for two reasons. First, that people aren't always aware that this has happened to them. A picture could be taken or shared without your knowledge. And secondly, there's some evidence that it's becoming more common, particularly as people have been in lockdown due to COVID-19. That includes a quite sharp rise in reporting of image-based abuse to the eSafety Commissioner. So what did we look at? Well, we now have 4 years of sentencing data about the Victorian offences, and image-based sexual abuse appears to be a growing problem. So we decided to investigate the issue to understand how these offences are being sentenced, who is committing these offences, and what sorts of context they're occurring in. We looked at research on the nature of image-based sexual abuse, who are the most common perpetrators and victims, and what kinds of harms can it cause, as well as legislation dealing with this issue across Australia, and police statistics on the number of recorded offences which were provided by the Crime Statistics Agency. And when we talk to people who work with or come into contact with victims, survivors and perpetrators of image-based sexual abuse, we wanted to understand how it all works in practice. This helps us not only to figure out what sentences are being imposed, but also gives us an idea of the context as well. So I'll hand over to the project team to take you through the main findings and policy implications of the Council's research.
Thanks, Arie. So when we look at the sentencing data, these are the things we look at. Firstly, how many offences were sentenced in our study period, in how many different cases, and how many different people were involved. Secondly, who was being sentenced? How old were they, and were they men or women? Were they being sentenced in cases that were made up of just image-based sexual abuse offences, or were other offences involved too? Thirdly, what kinds of links to family violence can we find? Do we think this is an offence that often occurs as part of family violence? And finally, what sentences were imposed and who was getting them? This step involves looking at the outcomes, but also at how other factors affect those outcomes. So to answer that first question, there were 306 different cases. Those cases involved 304 different people. So that means that nearly everyone was involved in only one case. And there were 478 image-based sexual abuse offences in total. So that means that there was quite a low number of those offences per case. 9 out of 10 sentenced offenders were men. And young adults were responsible for most of the offending. Over the last few years, the number of sentenced cases and offences has been gradually rising. So has the number of reported offences. The Victoria Police data shows a similar increasing trend to what we see here. And this is a trend that we expect to continue. Overall, the number of cases that are reported and sentenced still seems to be rising. In fact, as Arie mentioned, it seems as though there might be a bigger increase this year because of what's been happening through COVID lockdowns. This graph is a different view of what's being sentenced over time. We've split up the data so that you can see how many offences would distribute intimate image or threaten to distribute intimate image. Those are the 2 offences that came in 2014. And how many were one of the 3 older offences. Those newer offences came in partway through the 2014-15 financial year and started being sentenced from the following year. Now they make up 80% of all the image-based sexual abuse sentences sentenced in the Victorian courts. This suggests that the typical offence has changed over time, that it used to be something to do with upskirting, which is taking pictures secretly without consent and or sharing those types of pictures, and which often involves strangers. But now, the typical offence is to do with intimate images, where perhaps the picture was taken with consent, but the person in it never intended it to be shared. And that may be something that's more linked to relationships. Paul will take you through the next few slides. Apologies, it looks as though Paul is having some technical issues, so I'll take you through them. We also looked at the proportion of the offences that are reported to police that ultimately end up being sentenced in court. This is a rough analysis because it doesn't necessarily follow individual cases all the way through. That means it might actually underestimate the proportion of cases that are sentenced, but it does give us an idea. And overall, the proportion is about a quarter, which might sound small, but there are lots of reasons an offence can drop out. For example, police might decide not to investigate, or there might not be enough evidence, or the offence might get dropped as part of a plea negotiation, even though other related offences in that case remain. And when we compare this to other sexual crimes, it's actually quite a high proportion of offences that go all the way through the system. For most sexual crime, it's about 10 to 15%. But the overall numbers here are quite small. The research tells us that up to a quarter of Australians aged between 16 and 49 have experienced this. but the number of recorded offences is roughly 1 for every 3,000 Victorians. So what we think is happening here is that people who have experienced less extreme forms of image-based sexual abuse deal with it themselves or go to the E-Safety Commissioner. And so the offences that are reported to the police are the most serious. Ones where other offending is happening as well, or the victim survivor is afraid, or where they feel there's a real risk that the perpetrator will keep doing this to other people if they don't report. So when people were sentenced, how many image-based sexual abuse offences were involved in each case? In short, very few. 3/4 of image-based sexual abuse cases involved only one offence of that type, and 90% of cases had fewer than 3 image-based sexual abuse offences. But that's not the whole story. If we look at the total number of offences in each case, 3/4 of people had more than one offence in total. If we think about this along with the last slide, what it means is most people who were sentenced for an image-based sexual abuse offence were also sentenced for something else as well. So to answer our second focus question, who was being sentenced? Typically young adult men in cases involving one image-based sexual abuse offence, but also some kind of other offending. And that also suggests that it's the most serious behaviour involving other offending as well, that is going through the criminal justice system. These findings should be considered together with the answer to our next question, which was, how many cases were linked to family violence? Family violence is very common. Court records noted a link to family violence in more than half of cases. And that proportion goes up when we look at adult offenders, excluding the Children's Court, and when we look at distribute intimate image or threat offences. But in contrast, the capture offence, which was one of those older offences that targeted upskirting, had very low rates of family violence. So what does this mean? We think that the stronger link to family violence in those threat and distribution cases suggests that those offences often occur in a relationship context. And I believe we have Paul back to take you through the next few slides.
All right, sorry about those issues before. Now we're on to the fourth big question. What sentences were imposed? Overall, the most common sentences were community correction orders with imprisonment and fines following close behind. And the grey slice here on the slide is made up of a range of lower end orders, such as undertakings, discharges and dismissals, as well as special children's court sentences. The typical sentence profile has been changing over time. In family violence cases, we see more imprisonment sentences than community correction orders. And as cases linked to family violence make up a bigger part of cases overall, the rate of imprisonment has gone up and the rate of community correction orders has gone down.
So what does all this information mean? Our next 4 slides explain the implications of our findings, and then we'll wrap up. You'll remember that we wanted to understand how sentencing works in this area. That means understanding what the offence involves and looking at whether the sentencing response is doing what it intends to do. Our research suggests that image-based sexual abuse as we understand it now is different from what it was understood to be when Victoria's offences were legislated. The offences of distribute and threaten to distribute intimate image were enacted following the Victorian Parliament's inquiry into sexting, partly because at that time there was concern that young people in consensual relationships who shared sex were being sentenced for child pornography, and that led to all sorts of disproportionate consequences. But our research suggests that even though we do sometimes see that type of behaviour, it makes up quite a small proportion of the image-based sexual abuse offences that go to court. Instead, a lot of sentenced offences are linked to family violence, and they're part of a pattern of behaviour, often including other offending, that is used to coerce and control people, and that is very serious. Now, as we mentioned earlier, Victoria's image-based sexual abuse offences are in the Summary Offences Act, not the Crimes Act, and they are summary offences. This also seems to be a result of how we understood the nature of this behaviour in 2014. The Summary Offences Act typically includes offences that are less serious than the ones in the Crimes Act. It also provides for quicker ways of dealing with those offences. On the other hand, the Crimes Act has rules that allow for arrests in broader circumstances, and it has rules about searching for evidence. Some of those rules have been inserted into the legislation so that they apply to image-based sexual abuse charges, but not all of them. Specifically, some of the rules that make it easier to access computer systems aren't there, and that can make investigations more difficult, especially if there aren't other serious alleged crimes in the same case. Another result of Victoria legislating early, when our understanding of the nature of this crime was a little bit different from what it is now, is that our maximum penalties are comparatively low, lower than those in most other states. When judges and magistrates are sentencing people, they must have regard to the maximum penalty for an offence. That means that if an offence has a low maximum penalty, you would expect that to lower the penalty for all instances of that offence, not just the most serious examples which might actually receive the maximum penalty. So the fact that the maximum penalty is comparatively low might contribute to lower sentences. Also, sometimes people receive what's called an aggregate sentence, a combined sentence where a single term is imposed for all the offending in a case. And in those cases, we can't isolate what the sentence for the image-based sexual abuse charge was, separate from the other charges. Another possible side effect is that when you raise a maximum penalty, there are other flow-on effects. One of the flow-on effects we're concerned about in these cases is that sometimes people who have experienced family violence can be concerned about the effect on their abuser of reporting a crime. For example, they might still be living with that person or co-parenting with them, or afraid of escalating the situation. More generally, it can be quite hard to report a crime committed by someone you know, more so if the sentence could be quite serious. So there is a risk that increasing the maximum penalty could put people off reporting image-based sexual abuse, while the use of aggregate sentences might mean that it had a smaller effect on penalties than we might have expected. The last major implication of our research was this. One of the things we heard repeatedly while we were writing this report was that people don't necessarily realise that this kind of behaviour is a crime. That people who shared pictures or threatened to share pictures don't always realise that what they're doing is serious. And people who experience this think that it's their fault for sharing pictures in the first place, or don't realise that there are authorities that they can report it to. So we think that it's really important to improve education and awareness, not only to help improve the rates and experience of reporting, but also, hopefully, to reduce the amount of this offending that happens in the first place. We'd like to thank the courts and the Crime Statistics Agency for providing the data on which this report was based. We'd also like to thank the stakeholders who attended the roundtables we held in July and who gave us information as we wrote the report. That's the end of the discussion of our findings. I encourage you all to download a copy of the report from our website. The report has all the findings we mentioned today and much more. And there's also a 2-page fact sheet available on the website. We haven't included a Q&A component in today's session, but if you do have any questions arising from today's presentation, please feel free to get in contact. You can send an email to us using the email address here on the screen, and feel free to take a screenshot, or you can get in contact through our website. Otherwise, thank you to everyone for coming to today's session, and have a lovely afternoon.